This is Bloomberg Law with June Grasso from Bloomberg Radio.
I order the end to all of the lawless diversity, equity, and inclusion nonsense policies across the government and all across the private sector and the military.
President Donald Trump has tried to wipe out diversity, equity, and inclusion programs in the public and private sectors. And early this year, the National Institutes of Health began terminating thousands of medical research grants that don't align with the president's policies. More than a dozen states, researchers, and research organizations filed a suit against the administration, saying the cuts would set back crucial research by years, if not decades. They won at the district court level and at the appellate level. But the Supreme Court, in a 5-4 decision, sided with the Trump administration, clearing the way for it to cut nearly $800 million in grants, while legal battles over the funding play out in the lower courts. Joining me is constitutional law professor David Super of Georgetown Law. David, what kinds of grants were cut here?
The administration canceled thousands of grants the NIH had provided for research on a wide range of topics. Ostensibly, these grants were cut off because they related to diversity, equity, and inclusion, or because they related to gender or gender identity as understood by the administration. In fact, it took little more than having the word diversity or equity in the name of the project to get it cut off. Some projects that had nothing to do with race or racial equity or racial inclusion were cut off, but the district court found that disproportionately research into health problems that affect people of color were targets of this cutoff.
Federal Judge William Young, a Reagan appointee, said following a bench trial, this represents racial discrimination and discrimination against America's LGBTQ community. I would be blind not to call it out.
Yes, he also found that the cutoffs showed remarkable insensitivity to the health problems affecting women.
In the past, have administrations cut off grants for, arbitrary reasons or because they don't comply with the administration's objectives?
This is almost unheard of. Sure, if someone is taking a grant and they're not doing the work, they get cut off. But the notion that we wouldn't have given this grant, so we're simply going to cut it off, is extraordinarily wasteful, and administrations of both parties in the past have refrained from doing it.
Explain the Supreme Court's ruling, which was 5-4.
The question came to the Supreme Court whether to suspend the order that the district court judge had issued. And the district court judge did two things. He struck down the policy guidance the administration based its terminations on, and it struck down the terminations itself. 4 justices, the 3 liberals and the Chief Justice, voted to deny any interference with the district court's order, to let the court order take effect. 4 justices voted to stay the entirety of the court order, and the deciding vote was cast by Justice Barrett, who said that she wanted to stay the resumption of funding, but would not interfere with the finding that the policy guidance was illegal.
And what was the reasoning of the majority in allowing the government to withhold the grant money?
Their reasoning was that anyone who'd had their grant cut off should have gone to the Court of Federal Claims, not federal district court. And that's the place that it is proper to pursue debts from the federal government.
Can you explain what the difference is between, that part of the decision and the part of the decision that allowed the policy to go forward?
Yes. Justice Barrett held that the federal district courts are completely proper places to challenge the legality of guidance that is issued by the administration. So if the challenge is that this guidance is without solid legal basis, that it's contrary to the federal government's legal obligations, that it violates civil rights laws, those are proper claims to bring in federal district court and to get an injunction, she said. But she said that if you actually want money, that has to come from the Court of Federal Claims.
So that means that the challengers here would have to go to two separate courts and bring two separate actions?
Yes, she said there's precedent for that, and she asserted that that was the result of Congress's passing the jurisdictional statutes they have and the Supreme Court's prior interpretations.
And do you think that's a correct interpretation?
No, I don't. The Court of Federal Claims is there to handle a lot of routine matters where there's a question about the quality of the paint job that was done on a federal office building and the federal government's refusing to pay and the painting contractor wants to be paid. There's a need for that. That's useful sort of thing, but that's very different from a systematic violation of thousands of contracts asserting a power that has never previously been recognized. Those are the kinds of statutory and constitutional issues that have long been the province of the general federal court system, the district courts and the circuit courts of appeal.
So can the groups here, now that they have this judgment from the Supreme Court about the policies, can they now go to the Court of Federal Claims and ask for the money?
If only it were that simple. This was not a decision on the merits of those policies. It was simply about how the litigation should proceed. And Justice Barrett, joining with the Chief Justice and the three liberals, held that the litigation can continue in the First Circuit Court of Appeals about whether or not those policy documents are legal. And if they are struck down again in that court, the Trump administration could appeal back to the Supreme Court on the merits. She indicated that there were some open questions in her mind that would need to be resolved before a final decision could be made about the legitimacy of those policy documents. So she was only keeping the litigation alive. She wasn't resolving it in the favor of the challengers.
And the majority found that the government would be irreparably harmed if it had to pay out this money? How so?
Yes, that's a particularly disturbing part of it. They said that because the recipients wouldn't be able to repay the government if it was ultimately found that the money was not owing, that the federal government shouldn't have to pay out the money until after a final judgment is issued, which, once appeals are accounted for, could take several years. This is treating the entire matter as a debt collection issue rather than an issue of democratic governance. It could be that at the end of the day, the parties entitled to money will get some money, but the research will long since have been abandoned. The employees long since have been laid off. Many of the nonprofits will have been bankrupted by the long delay. And this is essentially saying that the federal government is too big to comply, rather than too big to fail, too big to comply, because the size of the grants it gives out and the importance of the grants it gives out are such that the recipients don't have the money to pay it back.
In April, the Supreme Court allowed the Trump administration to cancel $65 million in teaching-related grants. And in this case, Justice Neil Gorsuch accused the trial judge of defying the Supreme Court by not following that. When this court issues a decision, it constitutes a precedent that commands respect in lower courts. He also said recent federal judges' rulings on immigration and removal of leaders of independent agencies were also instances of what he said was judicial defiance. But the Supreme Court rulings he's referring to are rulings on the shadow docket, where there isn't full briefing or oral arguments or decisions sometimes.
Well, it's a very curious position they're taking. Most of the history of the Supreme Court has been through formal consideration of cases, oral arguments, briefs, and thorough opinions from the justices. Increasingly, under the first Trump administration, the Biden administration, and now the Supreme Court is not accepting full briefs, not listening to oral argument, not writing full opinions, sometimes not writing any opinions at all. And what Justice Gorsuch is saying is even when the Supreme Court is issuing an emergency order, and even when it's not at all clear what the basis for that order is, the lower court somehow must read the Supreme Court's mind. If the Supreme Court wants lower courts to follow it, it needs to tell them what it's doing.
Chief Justice Roberts joined the liberals in the case involving the teaching-related grants and in this case. Is that surprising in any respect?
No. Chief Justice Roberts has been very concerned about business climate and allowing businesses to function freely. And a federal government that isn't bound to comply with its contracts is very bad for business. If I were a private business person, I would be doing anything I could to avoid having to contract with the federal government because the effect of these decisions is that the contract isn't worth anything.
So as we've discussed before, the Trump administration has prevailed in a majority of its about 20 emergency applications to the Supreme Court. Often you have the liberal justices dissenting, and in this case, Justice Ketanji Brown Jackson wrote a solo blistering dissent where she repeated what she said before about the Supreme Court favoring the Trump administration, and she referred to the comic strip Calvin and Hobbes, which features a game of Calvin Ball. And she wrote, quote, "Calvin Ball has only one rule. There are no fixed rules. We seem to have two. That one and this administration always wins." So no fixed rules and the administration always wins. You can really sense the frustration in some of these dissents by the liberal justices. And Justice Jackson seems to be getting more sort of brazen in her dissents.
Well, she has, and it's not hard to understand why. Throughout the country's history, contract has been a central part of its law, and the notion that the government, above all, complies with its contracts has been central. We have a new administration that doesn't want to, and rather than bringing it to heel, this court is bending over backwards to accommodate it. That certainly does look like favoritism.
Is there any other avenue that the organizations and the states here can pursue if it would take too long to go to the Court of Claims, or is this sort of the end of the grants?
They can go to the Court of Federal Claims. There are significant obstacles to getting relief from that court. It's a real court. People do win real judgments there. I don't mean to disparage it in that way, but it's going to be a very difficult way to proceed. Lots of money that is owed probably will never be ordered to be paid out of that court. And the result of all of this is likely to be that many of these programs are indeed disbanded.
What stands out to you in this decision?
This isn't really a liberal or conservative thing. This is just a rule of law thing. And if the government doesn't have to keep its contracts, no one should do business with it.
Always a pleasure, David. Thanks so much. That's Professor David Super of Georgetown Law. The Federal Trade Commission is suing the operators of LA Fitness over allegations that they make it exceedingly difficult for customers to cancel gym memberships and other related services offered in their clubs nationwide. The FTC accuses Fitness International and its subsidiary of illegally charging consumers hundreds of millions of dollars in unwanted recurring fees as a result of the cumbersome cancellation process. The director of the agency's Bureau of Consumer Protection said in a statement, the FTC's complaint describes a scenario that too many Americans have experienced, a gym membership that seems impossible to cancel. Jill Hill, the president of club operations at Fitness International, said the FTC's allegations were without merit and that the company was confident it would prevail in court. Joining me is Sean Collins, a partner at Stradling. Sean, did this suit surprise you?
I'm surprised that the FTC is bringing this lawsuit. And the reason why I say that is, so California back in 2011, 2012, basically was the first state to kind of recognize that, you know what, if you automatically start charging somebody's credit card every month, you should probably make it easy for them to cancel as opposed to putting up a bunch of impediments to them being able to cancel, i.e., call somebody and then wait on the phone for 30 minutes until you get a hold of a customer service representative, or fill out 10 pieces of paperwork, because what the data suggests is that when a person has to stay on the phone for 30 minutes to cancel their membership or fill out 10 pieces of paper, they just say, forget it. I don't have time to do that. I got to go pick up my kids. I got to get to work. And then they end up being charged hundreds and hundreds of more dollars unknowingly just because it was so difficult for them to cancel. So California back in 2011 amended their auto renew statute to say if a person signs up online, you have to offer them the same mechanism for cancellation that they signed up for. Now, why was that important? That means that if I click the button on my iPhone, if I click the button on my computer to sign up, then I need to be able to click a button on my iPhone or click a button on my computer to cancel just as easily as I signed up. Now, the reason why I'm saying that is I was really shocked that the FTC brought this lawsuit because the federal law, so Section 5 of the FTC Act and ROSCA, do not really have that same exacting level of specificity that California, New York, Florida, Oregon, D.C. even has a similar mechanism now, and there's other states, Oregon as well, whereby you have to offer the consumer the same ease of cancellation that it was for them to sign up. And so that's probably one of the reasons why, I think it's one of the reasons why the LA Fitness is fighting it, amongst the other reasons. But if you read the complaint is kind of weird because they're saying, well, you made it really difficult for them to cancel. But then when you read the statutes that they're seeking relief under, they're basically saying Section 5 of the FTC Act, and then count 2 is ROSCA, and then count 3, they're saying you failed to provide simple cancellation mechanism. Federal law is not really specific on what simple cancellation mechanism means. So like I say, in California, we say simple cancellation mechanism means that if I click the button to sign up, I should be able to click a button to cancel. There is no same standard, at least that's been articulated under federal law. So I suspect that what LA Fitness is doing is saying, well, we didn't violate federal law by requiring people to come in and cancel. Because the other thing about gym memberships is most people sign up for the gym membership by walking into the gym and filling a piece of paper out. You don't do it on your iPhone. Not most people. Now, a lot of people may be doing that nowadays, but for LA Fitness, if I'm signing up for a gym membership, I usually have to walk into the gym, look at the gym, see if I like the gym, and then sit down with somebody to sign up. Now, I haven't seen the actual agreement for the sign-up, but there may be disclosures in that agreement that say, if you want to cancel your membership, these are the things that you need to do.
So then do you think this lawsuit came as a surprise to LA Fitness?
These lawsuits just don't happen overnight. The FTC didn't blindside LA Fitness and, LA Fitness woke up one morning and they were being sued. Typically what happens is probably 2 years ago, the FTC was probably getting a lot of complaints via the Better Business Bureau about people complaining about having a hard time canceling their LA Fitness memberships. And then they opened up an investigation. So they sent a CID, which is a federal civil investigative demand, to LA Fitness saying, hey, everybody's complaining about having a hard time canceling your membership. What do you have to say about this? And send us a bunch of documents so we can evaluate whether or not these are valid claims. Over the course of 2 years, they probably did this investigation, and then their findings were, yeah, you guys are making it really difficult for people to cancel their memberships, and we want you to pay them back. LA Fitness probably said, well, no, we're not going to pay them back because we didn't do anything wrong. We didn't violate the law. So they effectively challenged the FTC's findings, at which point, if you challenge the FTC's findings, the FTC reserves the right to file a lawsuit against you.
Which they certainly did here. Tell us what the suit alleges.
So their core complaint is they're saying that LA Fitness is intentionally making it hard for people to cancel their memberships to basically have the ability to continue charging them every month. And if you look at ROSCA, the third element of a ROSCA claim is you have to give somebody a simple mechanism of cancellation. The problem is there's never been any clear-cut definition of what simple mechanism of cancellation means. So LA Fitness can say, well, a simple mechanism of cancellation is exactly what I put in their contract. You have to walk into the LA Fitness gym where you're a member and tell people you want to cancel.
And ROSCA is the Restore Online Shoppers Confidence Act, which was enacted almost 15 years ago. So the complaint is specifically targeting this cancellation policy. You have to go to the gym's website and print out a form and either mail the form using registered or certified mail or submit it in person to a specific manager with authorization to process it. And sometimes it's hard to find that manager. So it seems like it's more than just coming in person to cancel.
Correct. So that's certainly the allegation, but here's the FTC's challenge. So that could be 4 or 5 people that had that issue. But if that's not a universal thing, if that's just a problem that 4 or 5 people in Southern California had at their particular gym, you're going to have a hard time proving that that was an institutional policy across all of the United States.
And one of the things LA Fitness comes back with is that the FTC is relying on ROSCO, and that was designed to address only online retail transactions. Is that a good defense?
It is a good defense because, to your point, the Restore Online Shoppers Confidence Act is exactly that. It is a statute that was passed to protect online shoppers, people who are shopping. It's really an e-commerce statute. Now, like I say, the reality of the situation with gyms is even in this day and age, the majority of people sign up for their gym membership in person. So, yes, there may be a certain subset of people who signed up for their gym membership online, and I don't know what LA Fitness, I don't know how their gym membership works. I'm not a member at one of their gyms, but I suspect that they have 2 paths for joining the gym. You can either sign up online or you can sign up in person. If you sign up in person, they probably have a different set of requirements for cancellation than they do for the person that signs up online. So if you sign up online, they probably offer you the ability to cancel your membership online. If you sign up in person, they probably have this requirement that you have to come into the gym and cancel in person. And the reason why that probably exists is if the person signs up in person, they probably never created login credentials. So the only way they would be able to cancel is if they walked into the gym to cancel. Whereas the person who signed up online probably had to create a user ID and a password to create their account. And so they now have the ability to log in online and cancel. So that's why, at least based on my initial read of this lawsuit, I don't know that ROSCA would fit for the business model of LA Fitness. So that's going to be a challenge for the FTC.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Sean Collins, a partner at Stradling. This is actually the second suit brought by the Trump administration focused on overly onerous cancellation policies. The last suit was against Uber. I'm June Grasso, and you're listening to Bloomberg. The Federal Trade Commission is suing the operators of LA Fitness over allegations that they make it exceedingly difficult for customers to cancel gym memberships. I've been talking to Sean Collins, a partner at Stradling. So, Sean, you discussed some of the problems the FTC may have to overcome in this suit. Why do you think they brought it?
Well, they brought it because they probably have a critical mass of complaints. And I suspect that when they were doing their investigation, they noticed that this was pretty prevalent. People were having a hard time canceling their memberships. And so they're trying to advocate on behalf of consumers that, hey, you need to offer them a more simple mechanism of cancellation. Like I say, their problem is that there is not a federal statute that I think specifically speaks to the conduct that they are trying to address. You know, what's surprising is you would think that California or New York or D.C. or Florida would be bringing this case. Because, like I say, their specific state statutes, their auto-renew law statutes, speak specifically to this conduct that they are referencing in this complaint. Now, I'm not trying to encourage these states to, and I'm sure these states have already looked into this on their own. And I suspect that LA Fitness probably has created their business model whereby they are ensuring that they're compliant with each one of these states. But, I mean, the reality of the situation is the federal law is not that great or not that developed. And I don't know if it's going to encompass the conduct that they are trying to pursue against LA Fitness here, which is one of the reasons why LA Fitness is fighting the case.
So, I mean, in April, the FTC sued Uber for making it too difficult for customers to cancel the subscription product Uber One. Is that different from this?
So it is different from the standpoint of, again, so we've always known the only way I can have an Uber account is if I download the app on my phone. So I can't, just go out into the street and flag down an Uber driver and say, hey, can you hand me a receipt and I'll pay you later? Like, I have to have an Uber app. So that is the type of business model that Roscoe was specifically designed for. So that case is going to be a lot more simple because, again, I can't catch an Uber without the app. So I have to have a user ID, I have to have a login, I have to have a credit card attached to my account. And so in that particular case, and I haven't read that complaint, I don't know the facts and circumstances of that complaint, but if Uber is not allowing me the ability to cancel my app in a very simple manner, I could potentially see that case from an FTC standpoint. Like I say, this one is just unique because there is still a critical mass of people who sign up for their gym memberships in person. They do not do it via their phone or their computer.
I mean, I think everybody who's tried to cancel any kind of subscription can relate to this, especially trying to cancel it online can be a mystifying process. And the Biden administration sued both Amazon and Adobe for allegedly making it too difficult to cancel subscriptions. Did anything happen with those lawsuits?
So those lawsuits are still pending, I believe, but here's the problem that the federal government has. You have the executive branch, i.e. the president, the FTC, and the enforcement bodies in D.C. that want to pursue these laws. The problem is the legislature is about 3 years behind them. So these laws need to be updated to capture the behavior. Effectively, these laws need to be updated to mirror New York and California's auto renew law statute. Now, that's a challenge because, obviously, in order to get federal legislation, you have to get all 50 states to buy in. That's one of the reasons why you have not seen that update yet. And so to answer your question directly is, even though the Biden administration and other administrations have been pursuing these cases, their challenge is their intentions do not match the current state of the federal law.
And under the Biden administration, the FTC adopted a click-to-cancel rule, which would have made it easier for consumers to cancel subscriptions. But a federal appeals court blocked the proposed changes before the rule was scheduled to go into effect last month.
So I suspect what happened there, and again, I haven't read that actual opinion, but one of the reasons why the federal court probably blocked it is because they're basically usurping the power of the legislature. So the executive branch doesn't have the ability to do that.
I mean, the FTC in 2024 said it receives about almost 70 complaints a day about recurring charges across, a range of businesses. I mean, is there any way to solve this?
So the way to solve it is for the federal legislation to basically mirror either New York or California. So New York and California and other states have been able to address this problem because it's like, all right, all we got to do is go to our own state legislature and pass this law on behalf of the consumers in our states. And so if the federal government wants to address this gray area, because that's exactly what it is, and businesses recognize it, is, all right, the federal statute is about 5 years behind all of the other states individually. And so to the extent that they're going to try to enforce these federal laws, i.e. the FTC Act, Section 5 of the FTC Act, or ROSCA, Restore Online Shoppers Confidence Act, if they're going to try to enforce it against us, it does not have the same bite or effect that the California, New York, or the other various state laws have. Now, you made a point earlier that I think is worth addressing. So you were saying that, it's always sometimes very challenging to cancel a membership. Now, that is a topic that has been ripe for debate. It's also one of the things that has been an impediment to passing a comprehensive federal statute. So the auto-renew process is ripe for fraud. And what I mean by that is sometimes when consumers offer you the auto-renew option, there are customers who get discounts when they sign up for the auto-renew option. So basically a customer will say, you know, if you sign up for our auto-renew option, we'll give you a 10% discount on your first purchase. Now, typically what happens, and I've seen the data for a lot of my clients, 20 to 30% of the people take that 10% discount and then right after they order, cancel. So if you think about that from a business standpoint, the business is losing money because they're offering you a 10%, sometimes 20% discount on your first order for you to sign up for the auto-renew subscription, and then you cancel your subscription immediately. So if I have a $10 product and I give you a 20% discount, I'm losing $2 on every transaction. So the compromise has always been, and this was because I basically have tracked the California legislation all the way through the California state legislature, dating back again to the early 2000s when they first started thinking about this. California basically said, all right, we recognize that businesses are kind of left exposed to potential fraud by customers. So what we're going to allow you to do is we're going to give you some grace to be able to save a consumer. Now, what does it mean to save a consumer? That means that before you cancel, even if I'm offering you the online mechanism to cancel, so you can cancel on your phone just by clicking a button, or you can cancel on your computer by clicking a button, I'm going to give the business an opportunity to save this consumer. Meaning, before you click cancel, I can ask you, why are you canceling? And the price was too expensive. I didn't really like the product all that much. Or, you know what, I only needed it this one time. I don't need it every month going into the future. And then you can basically have like 3 to 4, sometimes 6 slides where you're asking the consumer for data so that, A, you have the opportunity to upsell them, because you can say, all right, well, how about this? If I give you another 20% discount for the next 3 months, will that keep you interested in the product? Or maybe I'll give you these 2 other products for free with your next order. You're basically giving me the opportunity to upsell the consumer and save them and keep them on the subscription platform. Now, if they go through those 5 slides and they say, you know what, I appreciate the offers, still not interested in the product, click cancel. That is completely legitimate. That's legitimate in California, New York, D.C., Oregon, Florida, and at the federal level as well. And so I'm telling you that for context to say I know for a fact, I'm not an LA Fitness member, but it is a standard operating procedure for any business that wants to be successful. Before somebody cancels, you want to ask them, why are you canceling? So that's probably why LA Fitness set their model up to say, hey, you got to come in and talk to one of our managers, because that manager needs to know, where did we fail as a business? Did you not like the equipment in our gyms? Did you not like how clean the gyms were? Were there not enough squat racks? Were there not enough barbells? Were there not enough dumbbells? Did you not like the hours that we offered you? Because that allows me to improve my business going forward if I know why you're leaving me.
Or was it just too hard to get yourself into the gym? Always my problem. Thanks so much, Sean. That's Sean Collins, a partner at Stradling. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.